This podcast is brought to you by the School of Advanced Study, University of London.
Thank you very much, Peter. And let me say thank you to everybody who's here, and thank more particularly my learned brother, Judge, for having made it all the much easier for us to know how we should set our feet about this enormous and complex subject. For the sake of clarity, this rather complex topic can be subdivided into three parts. That is the application of English law and other legal systems in the British Empire and after independence. And the three parts are application of English law in the empire, 2, application of that law and its interaction with other legal systems in the empire before independence, and finally, application of that law and other legal systems after independence. In between these three parts will understandably be a myriad of other questions, because an empire, the size of the British one at that, encompassed a good many nations of diverse legal systems and customs. From this brief premise, one can justifiably conclude and say it takes any and many forms to constitute an empire. But in the process, this observation would indeed be very wayward if it concludes that in an empire, law and order are incapable of being maintained due to obvious conflict that must arise from this motley variety of habits, customs, and laws characterizing individual members of the empire and its laws, evolved from the English law and applicable to them, all as an overarching point of reference for their applicability and sustenance. Thus, both before and after independence, English law served and still serves as some form of judicial touchstone, in the sense that although wherever it migrated, English law sought to preserve the existing order, these laws and customs had to pass the litmus test of being not inconsistent with natural justice or with the British sense of fair play. The laws of the empire, as ready-made and effective tools for maintenance of peace and order, were in many instances received with enthusiasm, if enforced acceptance in other instances. Much as the English law, by virtue of its quality, where it was applied in the colonies, bore the seeds of sustainability in its original form, it has in good many post-independence colonies developed beyond recognition because of amendments effected to make it suitable to local conditions. Spotted in this instance is an ironic contradiction, but isn't it a paradox that a handy pointer to the value of change? Hence the saying, old order changeth, yielding place to new, lest one good custom corrupt the world. English law, like the Roman Dutch law, received acceptance as a ready-made tool. In this sense, like the Roman Dutch law, it is an old law that, because of seeds of sustenance in it, has survived into modern times. It wormed itself into acceptance even in the Muslim world and other places practicing Sharia law. This phenomenal expansion of English law into British colonies and various parts of the world reminds me of the statement that whenever an Englishman ventured into foreign lands, he brought with him the English law contained in his suitcase. This is recalled from Commonwealth Africa held in Arusha in Tanzania in 1988. While on the one hand, the saying that the sun never sets in the British Empire is plausible as a pat on the back for its achievements, it is on the other unwittingly acknowledging that the empire has been laboring under perpetual darkness of night. British colonialism resulted in the application of English law in all areas and territories under the control of Great Britain. The English legal system was rooted in common law, statutes, and judicial precedent. In various territories under British colonial rule, English law was introduced through preception or codification as well as case law. For example, a variety of versions of English criminal codes influenced penal codes in Africa, including the Indian Penal Code, the Queensland Criminal Code, and its derivatives, the Nigerian Criminal Code and the Second Colonial Office Model Code. The Indian Penal Code was originally adopted in some African states, but these countries later adopted the more bureaucratic Queensland mode. Regardless of the form adopted, the codes were based on English law, and many included a provision that they be read according to the English principle of legal interpretation. You will tell me when it is serious. Botswana, Malawi, Mauritius, Tanzania, Zambia are living examples in which the troubling provisions in the English Vacancy Act of 1824 emerged in their criminal codes. In this brief paper, I hope to use the experience of a few countries in the Southern African Development Community SADC region to illustrate the extent of the application of English law and other legal systems in the British Empire and after independence. Regard being had to considerations of time and space at my disposal. However, I intend to restrict this exercise to Southern Africa. This will be undertaken in three main ways. First, an attempt will be made to provide a bird's-eye view of the application of English law and other legal systems in the British Empire with particular reference to Southern Africa. Next, the paper will consider the contribution of English law to the Southern African law and the rule of law. Last, I will briefly reflect on the impact of English law during the post-independence era in these countries. Finally, some salient issues arising from the discussion herein will be addressed. Legal pluralism and or dualism are a consequence of colonialism. In almost all countries formerly colonized by the British, the colonial legal order was characterized by the coexistence of different legal systems. The law of the colonizers and the laws and customs of the colonized were juxtaposed in the pluralistic and dualistic arrangement. This trend was a corollary of the theory of individual use and rule, which was central to British colonial ideology. As has been argued, when in the course of colonialism one sovereign was replaced by another and the law of the colonizers, the colonists became the law of the land, and provision was made for the recognition in certain cases of a previously existing system of law, difficult questions were likely to arise. A slight diversion compels me in this connection to refer to the patriotic Scotsman and much acclaimed Professor T.B. Smith, the indefatigable champion for the maintenance and purity of all things Scottish, who could hardly disguise his mistrust of the English law. English law's behavior as follows. The common law cuckoo seems to have laid too many eggs in the eagle's nest. See his short commentaries. And I must caution you here, if you look for shortness in his short commentaries, you are up for a big surprise because there is nothing short in that. To return to the charge, the Southern African Roman Dutch law is a blend of indigenous Dutch customary law and Roman law. It was a legal system that prevailed in Holland during the 17th and 18th centuries and was introduced and applied into the colony of the Cape of Good Hope after settlement by the Dutch in 1652. At the end of the 18th century, the Cape was occupied by the British. Roman Dutch law was retained and confirmed as the common law of the colony. English, however, became the language of the court, and English legal procedures and the English law of evidence in both criminal and civil matters were introduced. The influence of English private and public law soon became apparent, more particularly because its sources were more readily available to practitioners than the Latin and High Dutch of the Roman Dutch old authorities. In Southern Africa, English law was introduced into the British colonies either through reception, codification, or both by the British. The countries in point are Botswana, Lesotho, Namibia, South Africa, Swaziland, and Zimbabwe. As we may remember, the first British occupation of the Cape of Good Hope was in 1795. The Roman Dutch law, which is the common law in most countries in Southern Africa, was received into the various territories on different statutory days. The various pieces of legislation in Botswana, Lesotho, Namibia, and South Africa, Swaziland, and Zimbabwe had the effect of introducing legal pluralism or dualism. In the beginning, our constitutional law was simply part of the British Empire system, based on the sovereignty of the British Parliament. However, Britain gave to the former colonies, newly independent states, the Westminster constitutional model. Coming to consider our criminal law, it has been largely modeled on the British system. The state, which conducts almost all prosecutions, litigates with the accused as if it were the plaintiff in a civil action and he were the defendant, and it seeks without striving unduly to prove his guilt beyond reasonable doubt. There is the presumption of innocence. This is a British approach. According to the continental view, the suspect is guilty until he can prove his innocence. Furthermore, the jury system, which though it had Germanic roots, came to us from England and included for a generation in the Cape colony of Good Hope the grand jury. The jury later metamorphosed into the tradition of assessors who are the triers of fact. Now, the contribution of English law to South African law. A leading publication that in my opinion speaks to the application of English law and Roman Dutch law is the one entitled The Contribution of English Law to the South African Law and the Rule of Law in South Africa. At pages 10 to 11 of the publication, the following summary of the contribution of English law to our Roman Dutch law of Southern Africa is to be found, and it says, the extensive additions to and modifications of our common laws since the beginning of the 19th century are what we are mainly concerned with, for it has been during this modern period that the influence of English law has come strongly into play. It has happened in various ways, some more direct than others. Sometimes there has been express statutory introduction of the English law. This has been very extensively done in relation to the law of evidence. We have provisions that where in respect of certain subjects, such as the admissibility of evidence and the examination of witnesses, where our existing law is silent, English law is to be applied. Close to the law of evidence in this context is the law of procedure. Civil and criminal, where we have taken over with modifications from time to time substantially the whole of the English system without copying all the detailed rules to be found in Archibald or the Supreme Court practice. In other branches of the law, important English statutes such as those on company law, merchant shipping, insurance and negotiable instruments have been copied by our legislatures with only such minor changes as have seemed to be necessary. As the learned authors also indicate, okay, thank you very much. As the learned authors also indicate, the other greatest contribution of English law to Roman Dutch law is the principle of binding precedent. Again, as the learned authors correctly point out, while the courts of the Netherlands paid considerable respect to prior decisions, our treatment of the Russian dissidenti of such decisions as positively binding on courts dealing later with the same legal problems came to us from English law, the post-independence era. While much of Anglophone African post-independence development is of great interest, this paper is limited to the application of English law order in its newly independent territories. On the granting of independence, the legislative power of former British colonies was vested in a parliament. In general, the institutional forms of the British parliamentary system were adopted. A cardinal feature of the judicial order of the newly independent territories continued from its colonial past as the division of judicial power between two systems of courts. Let me hurry to consider Lesotho and conclude with Swaziland. The Kingdom of Lesotho is one of the former British colonies, euphemistically referred to as the protectorates. Lesotholand, which is Lesotho, received the law of the Cape of Good Hope through the General Law Proclamation number 2B of 1884. It has a hybrid of mixed legal systems formed by interweaving of a number of distinct legal traditions. A civil law system inherited from the Dutch, a common law system inherited from the British, and a customary law system inherited from indigenous Africans. The Roman Dutch law let me say this. To their credit, the English judges who served in the pre-independence Lesotho did not flinch from applying peculiar and weird aspects of Basotho customary laws of the day, which had been woven into English criminal law of procedure. For instance, the plea after the accused has been found guilty in a homicide case to mitigate severity of sentence by asking the criminal court to take into account that he is yet to raise the deceased's head in a customary lawsuit where he would be required to pay 10 head of cattle as compensation to the deceased family. In this sense, they had clearly appreciated the virtue of restorative justice in Basotho society. Today, restorative system is par for the course in enlightened societies of the world. Yet, considering of raising the deceased head had scared the daylights out of my predecessor, but one, the former Chief Justice of Irish extraction, Mr. Colonial. Let me rush to Swaziland in conclusion. It will be a kind of a forced landing, I'm afraid. But it is important for you to consider that as a contrast. Where is Swaziland now? If you bear with me. The problem is I have got this pulse shaking. So this is Namibia. Yeah, here's Swaziland. Swaziland also applies the common laws. Section 252 of the Constitution provides that the principles and rules that formed immediately before 6 September 1968, the principles and rules of Roman Dutch law, common law as applicable to Swaziland since 22nd February 1907, are confirmed and shall be applied and enforced as the common law of Swaziland, except where and to the extent that these principles or rules are inconsistent with the Constitution or the statute. The common law of Swaziland is therefore primarily Roman Dutch common law as applied in the Transvaal in February 1907. This was done it's tragic, old age. By means of the General Law and Administrative Proclamation 4 of 1907, the effect of the proclamation was to make the Roman Dutch law, common law, the General Law or common law of Swaziland, applying to and governing all legal transactions in the kingdom, regardless of race of the parties. This means, in effect, that the Roman Dutch law of the Cape Colony, as adulterated by the principles of English law, was introduced into Swaziland through the Transvaal in 22 February 1907. At independence, the Kingdom of Swaziland adopted a Westminster-style constitution, which enshrined a comprehensive Bill of Rights, as well as the concepts of an independent judiciary, the separation of powers, the rule of law, and life was very good. The Independence Constitution theoretically created a constitutional monarchy, which was bound to function on the premise of a bicameral parliament. It also created the executive arm of government, whose head was a prime minister, who was the leader of the majority party in parliament. On 12 April 1973, the lifespan of the Independence Constitution was cut short by abrogation by the king. From then on, anything affecting the courts, the parliament, and the executive was held in bewildering consternation and disbelief throughout the Commonwealth. For instance, the indiscriminate arrest and imprisonment of journalists, as a result of which the legal fraternity and lawyers for human rights are constantly up in arms against blatant transgressions by the judiciary and its encroachment on human rights and the rule of law, is a regular diet. Talk of dead flies in the ointment. Full stop. Thank you.